Good afternoon, everyone who's in Brazil or anywhere in South America. But I must say good evening because of our dear Professor Carole Basri is in Israel. I always have to ask her where she is because, you know, she has multiple residents, multiple homes. So she is in Israel right now. And so good afternoon and good evening. I think we have about 85 participants. So welcome to you. It's a real pleasure to have you. This is our first Tea with Professor Carole Basri. The program will go on for every quarter and always at tea time, whatever you are, right? And I actually wanted to call it High Tea with Professor Carole Basri because Carole is actually British. She is not American. So you can tell us a little bit about that when I introduce her to you. Although I think that our two main stars here today need no introduction. João Elek, who's the moderator, also is known to everyone here. But I just wanted to tell you a little bit about these programs because we have every quarter in the morning, breakfast with Tom Fox, and the moderators are all only women. And then I had a lot of men write to me saying, this is this day and age, it's not inclusive. So then I said, great, we will have tea with Professor Carole Basri and we'll have men as moderators. I am going to be quiet most of the time, but the way it works is that Professor Carole Basri will talk about the latest that is going on in the anti-bribery, anti-corruption in the world that obviously would have an impact, would be of interest to all of us here in Brazil, whether in the corporate world, whether individually. And then João will be the moderator, but we want you to ask your questions in the chat, and please include your name and the company you work with or the firm or the consulting firm that you work with. We want to know who you are. So without further ado, let me tell you a little bit about my dear friend, Carole. She is one of the pioneers in the compliance world. When I heard her in Monaco, actually, in the Congress in Europe, and she was talking about compliance. I had no idea what she was talking about. And I turned around to see if anyone understood her, but she was very known already. She started her career as a lawyer. She's graduated from, is it NYU?
NYU Law School, and I went to college at Columbia University, Barnard College.
Yes, great. But then the reason why I get a little confused is because she was a professor at two universities, one of them, Benjamin Cardozo. She invited me to give her some classes there, also in New York. And then she went to Fordham, my school. And
wait, you're missing University of Pennsylvania Law School.
Oh, University of Pennsylvania, yes.
Which I also taught at Cardozo Law School, correct?
The Cardozo. Well, the reason why I would know that is because she would invite me all the time, and I was very happy to get to know her better. And today, I am very proud to say she's one of my best friends. But Professor Carole Basri has all of these incredible books. I'm only showing you one or two, but they're incredible books. And she is a huge, monumental name all over the world in compliance. We will have a draw of a chapter of one of her latest books. Carole, I will let you talk about that, but then I want to talk about João a little bit. João, like I said, needs no introduction. He is now the CEO of Tüv-Süd, and he has also been on the board of Eldorado, and before that, he was a compliance officer at Petrobras. He is a man that I know that has about 35 years experience in leading positions in Brazil. He was a Citibank, and he has also been in the different sectors and always with this very special touch with compliance. So without further ado, I'm here just to hear both of you. Please ask questions. We have our dear interpreter, Carlos Azevedo, who is in a different room, a Zoom room, and you can ask questions in Portuguese or in English, but please tell us your name and company. Professor Carole Basri, what a pleasure.
Thank you. It's a pleasure to be here with you, Isabel. I'm so proud of you. You're #1 in Chambers for anti-corruption. I have just enjoyed your intelligence and brilliance. And I want to thank you for the chapter that you do on international attorney-client privilege, which is world-renowned. It is the best chapter on that anywhere. And you're following about 35 different countries. And it's really the hallmark of international corporate practice by PLI. In fact, we just did a webinar together on that. And we just had hundreds of people listening to you. You are so erudite in everything you do. So thank you so much. And thank you for being a very, very good friend. I want to talk to you today about a few things. So I'm going to briefly go through in the next 10 to 15 minutes, some really important things that are going on. And I think the first thing we're going to talk about is stereocycle. This is definitely involving Brazil. So, but even if it wasn't involving Brazil, it would be one of the most important things happening right now, because we can actually see the deferred prosecution agreement. And I will let Isabel take care of anybody that wants to get a copy of stereocycle. There's been a great series by Tom Fox on it, so I'm not going to belabor it, but the Department of Justice and the Securities and Exchange Commission in the United States announced a Foreign Corrupt Practices Act, FCPA, enforcement action. The respondent company, Stereocycle, had a culture of non-compliance throughout the entire Latin America, LATAM business unit, and belies those companies that only have dysfunctional culture. This one was beyond dysfunctional. Stereotype had a culture of corruption burned into the DNA of the LATAM business unit, which was so thorough that it was documented via bribery spreadsheets and revenue analysis. And they had a special word for bribes. It wasn't chocolate, it was cookies. So that's
I heard of popcorn a lot, but
yeah, cookies. This is a new one. Cookies.
So that was in the document review. You could see that they used word cookies.
Yes, yes. Look at that deferred prosecution, because they talk about the scheme. They also talk about the remediation and the monitorship. And there was basically quite an extensive monitorship, and they talked about exactly what they wanted. So they went through the culture. They went through the risk assessment, the legal risk assessment. I want to be sure we talk about only legal risk, not operational risk, not force majeure, and not acts of God. Okay, those are like, you know, a war, an invasion, a political turmoil of any kind. Then there are the ones that are earthquakes, tsunamis, hurricanes, all of these things. Those are all not what we're talking about. We're also not talking about supply chain, which has become very important, but only so far as supply chain deals with a legal issue. So what do the documents say? Who was supposed to deliver at what time? That's legal. But when you get into how to make the supply chain work, that's operational. And I'm saying this because you want to make sure as lawyers, we're always doing a legal risk assessment, and don't get into areas you don't know unless you do it with the expertise, either in-house or outside. But don't pretend to have expertise that you don't have. That's where we can get and a problem as attorneys. So I just want to point that out because I've been seeing a lot of confusion in the area of legal risk assessment. Don't make it operational. Don't make it force majeure, act of God. Then they went through all of the 7 steps to talk about what needed to be done to make stereocycle and LATAM work. And they talked about the scheme of protection and talked about the training and the governance issues and policies, procedures, and internal controls that all needed to be revamped. They talked about the reporting lines and the compliance office. And Joe, is there anything I've missed? The auditing, monitoring, testing, reporting, the training, the incentives and discipline, the updating, how you do the investigation.
Well, I think this is all about it, actually, and I like very much the recommendation to have experts for each different area to make it more profound, to go in depth and make it thorough. Otherwise, you can miss details, and we cannot forget that the devil lives in the details.
Absolutely. Well said, Joe. So, and I think what Joe said was very important because you're taking a big risk as a gatekeeper. And this has become very important, by the way, being a gatekeeper as a compliance officer. You're taking a big risk as a gatekeeper. You have enough risk on your plate that you should get the experts when you need it for operational force majeure and indeed for legal risk assessment. We're not all experts the way Isabel is, for example, on Foreign Corrupt Practices Act. And therefore, it's very important to have that expertise in the area. You can't be expected to have that expertise if you're a general counsel, which means you have to be somewhat of a generalist. And you can't know all the issues in the same depth. It doesn't mean you're not good. You may be better at what you do than anybody I could mention in the law firm. But in the law firm, they do have the expertise in a particular area. So your job is to present the risk to them and let them walk you through it if you don't know enough about what's happening in the case law. And I have to tell you, I'm going to go through a rundown in a minute after I go through this. I don't have much time, but I'm going to go through a rundown of some of the new things that happened just in the past year. You cannot stay abreast of that. I do it for my books, and I always feel inadequate. So I talk to Isabel. I talk to a number of other experts. I have 4 books because I can cross-reference each book with each of the experts I have in each book. I don't pretend to understand international attorney-client privilege to the same depth, but I do know who to go to, and I do know the material to go back to. That's the key to doing your job well if you're a compliance officer. So stereocycle brings up the idea of monitorships, and that brings us to Lisa Monaco and her recent memorandum that was on October 28th, 2021. So that's less than 6 months ago, or maybe 6 months ago. Deputy Attorney General Lisa Monaco delivered remarks to the American Bar Association at the 36th National Institute for White Collar Crime Conference. Remember, white collar crime. And the reason I'm giving you the data is because it'll be easy to look for a link for it. She observed that corporate crime has, quote, increasing national security dimensions, that data analytics plays a larger and larger part in corporate criminal investigations, and that criminal schemes are taking advantage of emerging technologies such as cryptocurrencies and exploiting the investing public. But then she goes along to talk about the need for monitorships, which stereocycle talks about monitorships. She talks about having a robust compliance program, a good risk assessment, and she goes further. She talks about the culture of the programs, and she makes sure she talks about the Yates Memorandum. Now, what is the Yates Memorandum? And this was also in stereocycle, okay? What was in the Yates Memorandum? The DOJ reverted, means went back to the Yates memo that was done by Sally Yates when she was Deputy Attorney General, just the same kind of position that Lisa Monaco has. And she said, Yates Memorandum policy requires that cooperating companies disclose all non-privileged information about all individuals involved in misconduct. You can't send over the worst individuals, or you can't send over 2 or 3 individuals that are going to take the fall. You must take over all the individuals involved and all the information. The reverse of the DOJ's Rothstein 2018 guidance required disclosure only of information about employees who were substantially involved or responsible for. Those were the words. So the Yates Memorandum said everyone, 2015. Then the Rothstein Memorandum of the DOJ in 2018, again, under a different administration than the Yates Memorandum, required disclosure only of information of employees who had, quote, substantially involved or responsible for the misconduct, end of quote. The 2018 approach allowed companies at the expense of prosecutors excessive discretion in evaluating individual involvement and culpability. That was wrong. That is a government determination, not a company determination of who's at fault. And Director Gruel on October 13, 2021 remarks, and he's endorsed, and he's from the SEC. That's why we have the SEC involved, the Securities and Exchange Commission in the US, remarks that he intends to recommend aggressive use, quote, aggressive use of available enforcement actions, including admissions of wrongdoing. Hearkening back, I want all the people, I want all the information. We will make the assessment as the government, as the representatives of the people. So Lisa Monaco is saying that for the Department of Justice, and Director Gruel is saying that for the SEC. And this is a major sea change. And I think it's very important that you're aware of it. Now, that is mentioned in the language where they say all individuals and stereocycle. So they're all working together. You can see that there's a line of thought, and it's a sea change from Rothstein going back to what Yates had in 2015. Okay. Now, the other thing I want to talk about are 2 really important things I find fascinating. One is Google. And I sent that to you, Isabel, recently.
I loved it. We're doing an article about it, but please tell everyone.
It's article worthy. It's article worthy. And I think it's one of the most important things, because they're saying you're not supposed to go and teach your employees how to game the system, how to work against the system with attorney-client privilege. And attorney-client privilege is dear to my heart and Isabel's, because we would like all in-house counsel to have attorney-client privilege. They are a really good resource, whether you're in a common law or civil code country. And in fact, there was a recent article in ACC that talked about how the Paris bar last year tried to introduce attorney-client privilege for in-house counsel, and then was under pressure, I believe, from the law firms to withdraw that. And so, and they said this was causing economic harm to French companies. Okay. So there is a lot of good to be said about having employees being able to go to their attorney, talk about the problem and resolve it without them having to worry about the expense of outside counsel, and to know what the right thing to do is right at the beginning of a project, not when it becomes a problem. But when we look at Google, we see the opposite. They had actual training in how to write your emails so that you would put on the name of a lawyer who is in-house and never really being asking for advice and never being responded to by that in-house attorney, but putting the name and discussing which attorney to use and how to do it, and how to make sure that any of your business strategies, and we all know that only legal advice is protected, not business advice, how you could protect your business advice. And they spelled it out in emails because, of course, the employees, the first line of defense, the business people, You tell them about, you put the lawyer's name on and you're protected, and then they forget about it, has to be legal advice, and you really have to ask for the advice and follow it. All of this went out the window. And they ended up with really an indictment of the culture of Google. And Google shouldn't have put itself in that position. And the general counsel and the compliance officer should have been aware of this program because they wrote it. This is not like misinterpreting a case or getting some training and not quite understanding it. This is teaching them to do this and then instructing them on how to do it and then getting the email and not responding as an in-house counsel. So I think there's a real culture gap there. And when we talk about the tech culture that we see globally, and unfortunately many US companies like Facebook and Google, and we can go down the line, but this is such a blatant attack on the rule of law. It's a blatant attack on the rule of law. It draws into question all in-house counsel who have the privilege and how they can abuse it. And it's a roadmap for how to abuse it. And they give you all the examples and they show how it was endorsed. It was, I can't go on anymore because I'm making myself sick as an in-house person.
I know, fascinating.
The other thing I want to point out before I get to my little rundown, and stop me if you want, is Boeing.
How about 3 minutes?
3 minutes, but I'm going to talk about Boeing. There's a new book out by Gavin Newsom, and it is terrific. And I just want you to read you about Boeing. Boeing had some planes. I'm sure you're aware of those planes. 3 of them went down with crashes. The 737 MAX crashes brought the company Boeing to its knees, exposing decades of skimping and saving and cost-cutting and compromising that led to these tragic crashes of their planes. Boeing's merger with rival McDonnell in 1996 was key because it led to a wholesale change in the airline giant's ethos, much to the displeasure of the staff. Boeing executives, for example, now found themselves having to adopt the 515 rule. Does anyone know what that is? Very interesting. Imported from McDonald, which is the company they merged with, Boeing and McDonald merged, where memos shouldn't take more than 5 minutes to read and 15 minutes to write. Tell me how many lawyers can do a memo 5 minutes to read and 15 minutes to write, okay? And the idealism just went out. One insider told the author of this new book, it is about something else, I guess shared value. McDonald's executives, later described by federal mediators as, quote, hunter-killer assassins, clashed with Boeing's Boy Scouts, and the workforce grew increasingly disgruntled. In 1999, when engineers were told they would no longer get bonuses for in their contracts, it prompted the largest white-collar strike in the US history, with over 23,000 Boeing workers in 6 states walking out. And you had a 40-day strike. Staff discontent continued to deepen. In 2019, when Boeing launched their new plane, the Dreamliner, workers nicknamed it the bottom liner and the end of the liner because they couldn't get extra time to fix things because they said no overtime. Such was the mood of the weary workforce. Meanwhile, Phil Condit, Boeing's CEO at the time, was busy flying around the world in a new $50 million Boeing business jet he had commissioned with his 4th wife, Giselle. The conversion of the 737 was at that time the world's largest ever business jet. And he had, TVs, queen size bed, a sofa lounge, 42-inch screen, 2 bathrooms, one featuring a $250,000 water-saving AquaJet shower. Okay, this is what they were spending money on. Condit resigned in 2003. 2 weeks later, a Business Week expose revealed that the board had pressured him to go over his strategic missteps and also his womanizing. The married Condit had pursued a relationship with a customer relations executive in the company while he was married. So anyway, she ends up getting terminated. She went to see Condit in his office, reminded him of his promises that he had made her for extra money, and then he bailed her out with a big bonus, okay? Condit was replaced by another CEO, Jim McDermott, who arrived in 2005 on a $52 million deal, but placed cutting orders on the heart of the business plan. And basically they cut off and yanked off all the security features on the 737 MAX, the workhorse of the Boeing fleet, okay? And then they go on to talk about the next president who messes everything up, and he ends up with a golden parachute. Let's see, McKerney put cost cutting at the heart of his business plan. And then Dennis McMillanberg, who came a little bit later, he finished this off after he was fired after the Adidas Ababa crash, but got a $60 million golden parachute after the crash. I want to tell you that this was a culture that went on since the merger. If you remember all the way back to when the merger occurred, this was 1996. So Boeing was a trusted name, and then it had this merger, and you slowly see everything seeping out to the point where they don't stop these planes from going off. They don't take precautions because all they had to do was to change some of the computer programming that was on there, and they could have avoided the crashes, but they weren't willing to put the money into getting the engineers to look at problems. They put it into a $250,000 shower system on a 737 Dreamliner that was done for the boss.
Carol, I'm sorry to interrupt, but I was going to say our Embraer here was going to merge with Boeing. Thank God it didn't then, right? But this is a place for us to stop. And I think that's
fine. I think we've covered everything that I really thought was
incredible cases.
Right. And I would like to go back to the culture at Latam, because the culture at Google, the culture at Boeing, the culture at Stereocycle have something in common. And that's that there is no care for either their workforce or for the public that they're supposed to serve. And that does not build shareholder value. That decreases the value of the brand. And brand value, as I can tell you, you can always buy planes. You can always do a computer search firm or make airplanes, but you can never bring back the brand once you have desecrated it this way. It'll take years to bring back.
Yeah, that's a great point. It's to do with compliance. If you're a compliant company, if they cared for their workforce and their brand. But thank you so much, Carol. I
hope that met your expectations, Isabel.
Absolutely. No, the case that I love the most is Google. We're writing a paper about it in Portuguese, and we'll let you know.
Very
good. Thank you. João, how would you like to approach all of these themes? Because you, as having been in so many boards and so many companies in so many different sectors, you are almost an entrepreneur yourself, right?
That's correct. That's correct, Isabel. You know, I think that Professor Carole surfaced a lot of very important aspects in business life. This happens more often than anyone can imagine, everywhere practically. And it is very important for chief compliance officers to be very much aware of what's happening around them and what's happening in the company. When we think about this Google case, I think it is very much a lesson learned for everyone and should be part of compliance trainings how important it is to identify elements of company culture and try to direct, fix eventual mistakes and flaws in the corporate culture. Actually, this can be done professionally. Identify what are the incentives or what are things that really are appreciated by the culture of the company, and utilize those elements to try to direct the culture for where it should be. So give incentives, utilize the proper language to demonstrate what should be done and what should be avoided. And in this regard, I think we can ask Professor Basri, do you believe that the stereocycle capitalized on Latin American countries' cultural flexibility to perpetrate the cookie bribery practices so bluntly?
You know what? I don't believe that the culture of Latin America is a negative culture. I believe it's a very positive culture. Maybe it's because I see it through the eyes of Isabel Franco, and I see it through your eyes. There are many, many good people. What you had were good compliance officers, good general counsels of LATAM, who had a president of the company who ran the company as his personal, I don't know, candy store, personal candy store. And he was under a monitorship already. And there were still bribery going on that they found out afterwards, and they didn't know what to do. I really believe that the problem was they didn't have board oversight. And
board oversight.
That was right, because he chose the board from the people he knew. He didn't choose boards that were, you know, the largest shareholder or whatever. He owned so much of it that he could choose the board that he wanted in a way. And this allowed it to go on. His friends. This is not the way this is not corporate governance. Duty of care and duty of loyalty. The loyalty was not to the company. The loyalty was to the president. And that was incorrect. And he wasn't working with his, I know I'm speaking out of turn, but I don't believe he was working with his general counsel and compliance officer. I can't tell you why I believe that, but I believe that that's not what went on. I think, you know, we always talk about Morgan Stanley and the rogue employee, but what about a rogue president?
That's correct. And, you know, in many companies, you can understand or easily identify the level of commitment to an ethical culture when you understand the reporting lines and the veto rights of the compliance officer. When you have someone who can do whatever he wants with no veto or with no one surveilling what he's doing.
Exactly.
He has the freedom to circumvent controls, to put people, his friends, in oversight functions, and actually they are not acting. And then things can happen.
Exactly. And I want to say also in Petrobras, having analyzed it, but you know more than I do, so you can confirm, I think it was because the person at the top was a person who acted on her own. And you could have had good people under them. But when the top of the whole reporting line is the problem, it's very hard to get around it. Well, it's hard enough if it's a reporting line that you have to report through to the CEO. But when it's the CEO, it's a real problem. And this is the issue for me. People understand what needs to be done, but you cannot do that. I mean, also, if we talk about the meatpacking case, JBS, talking about Latin American culture, is that correct?
Yes.
When they put the grandfather in jail and the father in jail, they looked to see who they would get next. They got the grandson as the head of the company. And the grandfather was directing things from jail. So but what could they do? They were a publicly traded company. They had been bailed out through the government, as I remember. You can correct me if I'm wrong. So, I mean, they don't want to put all these people out of business, and it's one of the biggest businesses that there is. So you had to work with it, but it's a terrible situation to work with. But I cannot condemn the Latin American culture. I condemn the culture that allows an elite to believe that they own their company without any repercussions from civil society or the government or anybody else, that they are a law unto themselves. This is what's the problem here. And that's different than just saying Latin American culture. I think that's too easy.
Well, I think that what's behind that is that the tone at the top is always the most important component, and let's say one of the most difficult to be shaped in a company and in the culture and in a compliance program. And Latin American culture is very high on close relationships with people. They are friendly, they develop good and strong relationships. And when this is inside the company, you tend to trust more those who you know and who are your buddies, instead of applying the constant skeptical and testing and controlling behavior that should be in place. And when this comes from the top of the company, this type of message is like an allowance for everyone to behave apart from the controls. And Correct. This is where I think that the cultural aspects with the wrong message from the tone at the top can get mixed and can cause these very serious impacts. And in this case, yes, please go ahead, Professor.
That's the phrase that I was searching for, tone at the top. And I think you hit the nail on the head. So it's very hard to be what they call a good citizen corporation if the tone at the top is bad. That's it. That's just it. And in some ways, this that you said, Joe's tone at the top, is what I find similar in all of these things, the tone at the top.
Absolutely. The case you mentioned, you described so well, the Boeing case. When you have executives that are more committed to their compensation packages than to the sound and safe products to be delivered to clients and to users, and that's really terrible. This is the wrong tone at the top, actually.
And this is what happened in Boeing and Google. So it's not just Stereocycle, it's Boeing and Google. And I think if you look for any of these, multi-billionaires that we're talking about that have these tech companies, there is a situation where a human being with so much becomes intoxicated with that power. And you don't get a good tone at the top. You don't get humbleness. A good leader serves. He serves his company, he serves his society, he serves the, what can I say, humanistic rights, the true way to go. And this is what is lacking. And it shows in the tone at the top, as you said, shows.
Yes, that's absolutely correct.
So I'm wanted to hit on today culture, because I'm going back to the culture we're seeing on the world stage, and it's bothering me. It's bothering me tremendously, and I think it will be reflected in all of our other institutions. I think we're ahead for a bumpy ride, unfortunately, because when we see tone at the top that is so abusive in nation states or in tech giants or in major companies, major meatpacking companies, major airline companies, major petroleum companies. When we see this, it then reflects in how we look at the world. And I think we're going to see more of it because we have to hit a point where it stops. And I'm hoping that we are saved from ourselves and humanity saved from ourselves by getting there. And that's why I believe so much in fighting corruption and in compliance, because we really are the first line of defense against this tone at the top. We're the ones who are mandated to look at culture. And, you know, culture is reflected in so many ways. I mean, just the CC of attorney-client privileged and mentioning a lawyer, that shows culture.
Definitely. And can you imagine when we are talking about a relatively nearby future, when you get more and more of these autonomous vehicles, if you don't have the commitment of senior leadership of the company to develop safe and reliable products, the type of bumpy rides that we can have in the near future. And this is really a serious component. If you have people like, let's say, cases in Boeing that you are more committed to your compensation package, to the end product, with these autonomous vehicles, this can happen all the time and can be very dangerous.
You point out such an important point. I have been working lately on artificial intelligence and how we run compliance programs on it. And I've been giving, I've given a set of talks with Oxford University on it. I did one about 3 weeks ago. I did one in November. And I'm really trying to develop the protocols. The problem is that you have data sets, and those data sets have to be picked by people. And people have, whether they know it or not, racial, ethnic, all kinds of slants, gender, you would be amazed. And then how you label that data set then needs to be looked at, because that's where the artificial learning comes in, and they go out and look for more like that, and more for like that, and more for like that to learn. And if the data set, for example, is done in a period when all the pictures are of a certain type, for example, for visually identifying people, you can get prejudice mixed in. If you're going to look at, you know, the vehicles, you need to look about deep fakes, because somebody can put a picture up in front of a stop sign and manipulate the data set itself with a picture, because it can't tell with perception, is it a picture or is it a fake or real? Only a person can do that sometimes. So there are massive, massive pitfalls, yet this technology will come out because it is a game changer. It's more than data analytics. It's much bigger than data analytics. You can create now Mozart material by learning how Mozart theory works and come up with new pieces that are Mozart. And you own them. Mozart doesn't own them anymore. You can do that with paintings. You can look at a painting and see how in fact, there was an art gallery showing where they showed Mozart and Rembrandt, and they learned strokes that Rembrandt makes, and then took another subject that he hadn't done and did it as if Rembrandt painted it. It's amazing. So if you can do that, think about what you can do in medicine with pharmaceuticals. Think about what you can do that with cures for disease and creating disease. Think about the good and the bad potential. It's like when we got fire. It's potential for good and for bad, very deep. And compliance is the only tool we have to deal with it. So if you don't think as a compliance officer that you're in an important place, then you're completely wrong. You are in a way more important than anybody on the board of directors, and anybody in executive management, because you have all the knowledge available and you know how the knowledge is made, and you're the only one who can look and oversee how that knowledge is made. That is so powerful. And I don't think people realize how powerful that position is and how much responsibility as a gatekeeper you have. And I think, Joes, you said it very well.
If I may,
I
have a question. I think that the examples that Carol gave us are phenomenal in terms of tone at the top. So if you're a chief compliance officer in one of these huge companies and you see the tone at the top doing everything wrong, what do you do as a compliance officer? I hear you when you're saying that you don't know the power that you have. In the United States, I think I know what to do, but what do you recommend to people all over the world when you see something going wrong in the company you work for?
Well, the first thing is say something and do something. Not just say, but say something and do something. Now, I will tell you a story for a minute about, I was asked to look at a problem many years ago for an American lawyer. This may be ages ago. And it was about hear no evil, see no evil, hear no evil, speak no evil. And they asked 5 different people that were considered ethical advisors what they would do if there was something that was dumped into the river that was toxic. You knew it was toxic, you knew it would hurt people, and whether you had a responsibility to report it. And I can tell you, back in the late 1980s, I was like the sole voice that came up with, out of all these experts, you need to report it, people are going to die. Everybody found a legal reason. There wasn't enough attorney-client privilege, there was too much privilege, they didn't know who to go to, they didn't know what to do. The answer is you have an ethical, moral responsibility, and I can cite you the place in the ethical tenets on the model rules where it talks about it. But if you're seeing death or major bodily injury, you may report it. No, you must report it. Even though it uses the word may, you must report it. You must go out of your way to do that. When we see something like that, it shocks the conscience. So the first thing you do, though, is you do it in a way that's sensible so that it will be heard. You work with your outside counsel to get enough counsel letter. You make sure that you already have a relationship with an outside counsel as an in-house counsel so that you can get the backup on this quickly and that they're of like mind. Because all you want to do is go to somebody who's going to tell you you're crazy, people won't be dying, and you know they will. So you have to do that. And you have to go back to a famous case, it's a US case, Gambro, where the general counsel was also the inspector for the dialysis units and knew they were all defective. Well, back 30 years ago, he was not only fired for saying it, but the Bar Association censured him for saying something. We have come a long way because we're not getting censured for doing that. We're being applauded for doing the right thing, at least in some circles, okay? And I believe that there is a need to do that, but that's why we need good government, free speech, and we need freedom of the press. Very important to have those things in place in society. And then within the organization, have a system where you can tell through reporting lines, the executive management, the CEO, the board of directors, and make it their problem, not just your problem. And then you have that of counsel letter, and you have a lawyer there that also has an ethical responsibility to think about reporting something. Again, it's may, it's not must sometimes. So it depends on your ethical responsibilities under your code of conduct. But I don't think that you're going to be censured by your bar association today. I don't think that you'll be fired and not be able to say something about it. Okay, that I do think we've progressed from. But will you lose your only client? If you're an in-house counsel, you may lose your job, yes. And you know what? You may have a conscience, and that may be the proudest thing you've ever done in your life. And that's something worth doing. It's worth doing the right thing. But I can't tell you how it is, because there is an energy that we all know is there. And we are all being watched, and it's not just on a camera. So we're all responsible for our deeds, and we're responsible to society, and we're responsible to our own souls. And that's as much as I can tell you, but
yes,
you have to be careful in doing it. I also suggest, if there are hot documents and you know about them, and you're talking to somebody, and this is something I've learned in anti-corruption, if somebody comes to you with those documents and you think they're not going to be safe, then you tell them, put them right up, get them to the internet and put them up there. Because once they're up there, they won't want to do anything to you. They have to get those documents off. And I always say that because when I was in Iraq, I was told a lot of information about some scandals with contracts and oil and things. And I said, don't tell me, I'll get killed, but do me a favor, go out and get it on the internet so that you're not going to get killed, because I don't want that on my conscience. And
João, there is a question here from.
It's a very interesting.
Yes, Carol.
The question is from Ardelio. He's from Azevedo Sette law firm,
The
and
founder,
it's a very interesting question and very much aligned with things that we were discussing here. The question is the following: how do you see the future of compliance on metaverse and virtual scenarios?
I think metaverse is like looking at a parallel universe that doesn't really exist. So I will tell you that my grandchildren 3 or 4 years ago were building farms and towns on these games, and they were asking for money to buy tokens. And Nana once offered it, but said, you know what? You're not getting anything for this. You're not able to touch the animal. You're not able to live in the house. This is all a fiction in your mind. Now, saying that, I still believe that you have to act with the same ethical intent, because they are training us to abuse our fundamental moral standards by giving us a fake place to go and saying it's okay. Do you remember the games where there was a game, how many pedestrians can you kill? And that was the video game that people were playing. That prepared us to the idea that we'd have automated cars. And this is what we're all scared of, because we know the human potential is that we'll want to go and play that game in real life. And if you make that metaverse too real, you create an environment that may be an outlaw environment. So I say that the same ethics have to exist whether you're in the metaverse or you're here, because you never know when those two will collide. And they will collide because of artificial intelligence. Remember what I told you about deep fakes? Metaverse is deep fake. It's the ultimate deep fake. You can't afford Chanel, but you can get a whole Chanel outfit for $1 on the metaverse. What does that tell you about going to Chanel and robbing Chanel? Because it's only $1 and you have it on the metaverse.
Right. Carol, this is so interesting, but unfortunately our time is almost up.
Well, I had a great time. Thank you both.
We'll do it again in 3 months. Thank you. Professor Basri was so kind and generous to get special approval, authorization from LexisNexis to send us copies of this, because as you can see, the books are huge, very difficult to mail from the United States. But
yes, I was very concerned that I wouldn't be able to get it to the person that was
Right.
interested. So I'm so glad, Isabel, that you thought of this creative way to do it. And
Absolutely.
if you want to make, let's say, chapter 2 or 1 or 3 available by email to anyone, I'm more than happy if you do that.
Right. Well, with that, we are hoping to have Professor Carole Basri again here in Brazil. She has come to give us advanced workshops many, many years, sometimes 2 or 3 a year. She has many alumni here that are in attendance today, and she will come towards the second part of the year of the semester. She will come and give us an advanced workshop again. We're just working on dates since we're back to the real world. So thank you so much, João Elek, again. Thank you.
Thank you. It has been an honor.
I think it's been very, very interesting. And all of you, the participants who stayed until late, and especially a very special thank you to our interpreter, Carlos Abelera, and the director of marketing of Azevedo Sette Advogados, who's here always with us. Thank you.
Thank you.
Bye.
Bye.
See you next time.